Welcome back to KBC News Check. On this second hour, we are looking at mediation, and maybe question is, what is mediation, which is the most effective and popular ways of resolving a dispute without even having to go to court. And this is where you find two people who have a dispute. They look for a neutral third party for mediation without even having to resort to the judiciary for a case. And we will be knowing all about arbitration here in the country as I host guest James Mangerere, who is the President, Mediation Training Institute. Actually, when I was preparing for this interview, somebody asked me, there's a Mediation Institute in Kenya?
Yeah, we have the Mediation Training Institute East Africa that has been around for the last 20 years now. And we train all over the continent of Africa. We have a branch in Kenya, Uganda, Tanzania, Rwanda, Burundi, and now a new branch in Zambia, in Lusaka, Zambia. So we train in different areas in English, Spanish, and French, both in East and West Africa. Yeah.
And I'm looking at a Mediation Institute. More specifically, you're training just the mediators, or what exactly do you do at the Mediation Training Institute?
First of all, probably I just introduce myself.
Yes.
My name is James Mangerere, the President of the Mediation Training Institute, East Africa, and also a Director in the International Mediation Institute, Netherlands. Also a distinguished fellow and a governor in the International Academy of Mediators in the United States. And also the President of African Mediators Association. What I've been doing, apart from being an advocate of the High Court of Kenya for the last 25 years, I've been, most of that, my life, I've been doing mediation. I've been training mediators for the last 24 years now.
Maybe perhaps you can tell us what is the difference between private mediation and the litigation, and what does it, why should we be leaning more on mediation as opposed to the conventional litigation in court?
First of all, it's important for the public to understand what mediation is. Mediation is an alternative dispute resolution process, alternative to traditional litigation. There are so many other alternative dispute resolution processes, and the reason why I'll tell you why mediation is different later on. We have negotiation, we have arbitration, we have conciliation, we have neutral evaluation, we have adjudication, we have arbitration. All those are alternative dispute resolution processes. Mediation is superior because of a number of issues. One, you empower people to make their own decisions. If you compare it with the court system, the court makes a decision, listens to the parties, and eventually makes a decision on their behalf. In mediation, you empower them. It becomes a self-determinative process. And usually decisions made by a third party who may not understand the substratum of the disputes are either where one party wins, another one loses. And the party who loses all the time is disgruntled, and they want to find another way, and the war continues. And the process of litigation also destroys relationships. So the reason why mediation is superior among all the alternative dispute resolution processes is that it is voluntary, it is confidential, and at the end of the day, it's self-determinative, and at the end of the day, parties are empowered to make their own decisions. And therefore, you don't have to struggle to execute that decisions, because that's just come from the parties themselves.
And for the viewer who is watching, comparing the prices,
yes,
is it cheaper than the traditional conventional
mediation is not only cheaper, it is faster. Cases take years to resolve in court. Look at especially matters like land matters in court, which can take up to 17 years in court. Succession issues that have taken up to 23. In fact, I had another case recently in Nigeria where a succession matter has taken 60 years to resolve. 60 years, and a number of generations of judges and lawyers have handled it. Some of them are dead and long gone. It's being handled by their grandchildren. That matter was recently resolved in one day. So mediation matters that can take years to resolve in court can be resolved in a day or in a week, the shortest possible time. Mediation is not only expeditious, it also, you make sure that the decisions that you make are decisions that come, it leads to what we call win-win solutions. And the reason why people are not using it as much as possible in Kenya is lack of awareness. the public does not know that there are better ways of resolving disputes. In fact, even the Bible says, my people perish because of lack of knowledge. If the public knew the importance of mediation or resolving disputes, in this country, like other countries, we would be having several mediation centers everywhere. People need not get into the formal justice system if they can be able to resolve their disputes expeditiously in a way that results in creative solutions, in ways that are people come out, both of them being winners, in ways that maintain relationship. People will never have the cause to go to court unless we're only dealing with matters that are pure points of law, because a mediator need not be a lawyer. Anybody can do mediation. But if you see most of the disputes that we have in this country, you find that people are emotionally attached to those disputes. And the issues where people are emotionally attached, be it a commercial dispute or a community dispute, those issues cannot be resolved rationally, the way people resolve their matters in court. And that is the basis upon which I think I'm here today to tell the public about private mediation. I'm talking about private mediation because we also have court-annexed mediation, which is...
Actually, that was my next question. Other than the court-annexed mediation, which we know, I have at least worked in court for a number of years, and I've seen how it works. Which are other types of mediation are there, and what cases can be taken there? We know some of the capital offenses cannot be... We cannot have a discussion, a mediation in regards to capital offenses like murder.
You see, what you have just said, I need to demystify it. If you look at our Constitution, Article 159, 2C of the Constitution allows 3 ways of resolving disputes. That is litigation, alternative dispute resolution where mediation is part of it, and it also allows traditional dispute resolution mechanisms. There are cases, like what you have just mentioned, the cases of murder, that have been resolved through traditional dispute resolution mechanisms. If you look at the system, and the viewers can go and Google, there's a case from Isiolo known as Republic versus Mohammed Abdo, where a murder was committed. Mohammed was arrested and taken into custody in preparation to be arraigned in court. The 2 communities sat together, and they agreed that the one community will pay the other 50 camels as blood money. The father of the deceased swore an affidavit to the Director of Public Prosecution and requested that the matter be withdrawn under Article 159 2C of the Constitution. The matter was withdrawn and settled. So there are matters that can be resolved through traditional dispute, which is within the Constitution. People may say all these offends the Criminal Procedure Code, the Penal Code, but any law that is inconsistent with the principle of the Constitution itself is not unfolded to the extent of its inconsistency, because the Constitution is superior law, which allows traditional dispute resolution mechanisms.
And still on mediation, I've seen mediation being criticized in northern part of Kenya, where either somebody has raped a young girl or, have done atrocities, but the community sits and they do mediation.
I think what they do is not mediation. It's not mediation.
That's where I'm heading. Doesn't this, for example, the case you've just mentioned, doesn't this deny justice to the person who was killed?
There are gender-based violence cases that cannot be mediated, like defilement. We just got to go through the system. Imagine the case of defilement, you were talking of a young boy or girl who has been defiled. You can't sit and mediate that dispute because this person does not have consent, the power to consent. They do not have the capacity to consent. And therefore, the Constitution has identified some issues that cannot be resolved outside the court system. And there are those ones that can be resolved through the court system. I remember, even the case of murder you have just talked about, in our traditions, if you go to the Pokot, for example, you realize that when somebody committed murder, even before these laws came into place, the people paid blood money in form of taking goats into 2 houses. They used to have the grass-thatched houses. You push enough goats into that particular house. If you fill in 2 goats, the payment of blood money is done and the matter was resolved. That has been there since time immemorial. But even if the Constitution allows this matter to be solved through traditional dispute, there are some exclusions, and there are many, like what you have talked about, development and some other GBV issues. Cannot be. But we can mediate domestic violence so long as the mediator has been trained properly to handle domestic violence. Other GBVs are excluded.
I'm also looking at how as MTI and other stakeholders, you can better sensitize Kenyans? Because just like you mentioned, a case that, you know, has taken 60 years was resolved within a year, right?
Within a year or within a week or a day.
Within a week.
Yes, exactly.
You know?
Yeah.
And a lot of Kenyans don't know that this is an alternative way of resolving disputes. Faster, cheaper, and
in a way that maintains relationship.
You become friends.
Exactly.
Despite the dispute.
In fact, there is a specific case which I really want Kenyans to know. I may not mention the names. In this case, people had stayed in court. It was a land matter from a place near Nairobi here. People had stayed in court for 17 years. There is a student I trained some times back who went to his father's law firm and told his dad, this matter has been here for 17 years. Allow me to mediate it because I believe mediation works. His father was initially very skeptical, but eventually he gave in after the young man kept on insisting, because he was a trained mediator, and he allowed the two parties to go. One of the hotels here in Nairobi. This matter that stayed, a land matter that was in court for 17 years, was resolved in 10 days.
10 days.
10 days. People who were coming out of that hotel were shedding tears. Tears of joy that the matter had been resolved. Tears of bitterness because it has caused a lot of animosity within those families. It has destroyed relationships. When this young man came to his father's law firm and told him, Dad, this matter has been resolved, the father was not amused, because he said, you can just solve this matter within a week. Where will we get money for rent, and etc., etc. But what I'm trying to tell you that as soon as Kenyans realize the importance of mediation, the moment they realize that and they embrace it as a form, a best way, we develop what we call a culture of dispute through mediation, will reduce the backlog of cases in courts. Our courts can be more efficient because then they'll be handling fewer cases, the judges that we have. Right now, if you look at the courts list in court, judges have 102 cases lined up in a day. They are human. You expect them to handle all those matters? No. Others are mentions, others are hearing. What I know is that the judge can hear one case a day if it has 5 witnesses, because they have to be processed. How many cases do we have in court? More than 700,000 by last year, the statistics I had. If each judge can hear 1 case in a day, how long is it going to take us? And we are still filing cases in court. That's why the public needs to know that cases like family disputes, succession, siblings, business disputes, cases like community disputes, workplace disputes, employment, and other issues, these are issues that can be resolved through the mediation. You need not go to court. Right now, if you go to the diaries of the courts, they're already closed for 2025. In fact, matters are being fixed in 2026 in September. And by the time we come to December, we shall have close to 2027. Why should we clog the courts with all these matters when we have alternative ways of resolving disputes? And that's the importance of private mediation that I'm talking about. We call it pre-litigation mediation. Instead of people going to court and then matters are referred from court to mediation, we are establishing mediation centers in different parts of the country. People can approach those mediation centers and have their matters resolved. It's only after the mediation process failed to resolve a case is that when the person can have the chance to approach the courts. And in fact, the courts need to reach a point where they need to demand that before you file your matter in court, please give us a certificate showing that mediation has been attempted and it has failed. And this is the policy that is there in the United States of America and in other countries. I've had a chance to travel to other countries just to benchmark and see what other mediators are doing. I was in Brazil. I had a conference in Sao Paulo where I had a chance to talk to a number of mediators, and they told me, in fact, in Kenya, we are less than 5,000 mediators. In Brazil, there are 500,000 mediators, and they're working. They have established mediation centers everywhere, so people can approach the mediation centers and have their matters resolved. Each mediation center has got a panel of mediators who are under very strict code of conduct. No quack can have an opportunity of joining a mediation center, and therefore these mediation centers have a reputation. They have already established what we call a standalone mediation act, something that we are missing in this country. In fact, the challenges we're having in this country is because people are coming up with different legislations. Now they have attempted with the alternative distribution bill, which is flawed. Others have come up with what we call a mediation council, and they have put it under an act of parliament without going through the normal procedures of stakeholders engagement, public participation. People are trying to find shortcuts so that they can entrench themselves in the system of mediation. What I can tell people, I've had meetings with mediators in Israel, South Africa, Iran, in Australia, Dakar, Senegal, because I sit in different bodies in this world about mediation is, and I've seen the experiences in those countries. What I'm only asking us in the country, especially our mediators in this country, let us put things right. Recently, India worked very hard. After fighting for a very long time, they have established a Mediation Act of Parliament, which sets standards of practice, standards of training, to eliminate the quacks who come to mess up the process. If you go to South Africa right now, they are working on a mediation appeal. Very hard work, and very soon, I think by February next year, they'll be having a Mediation Act. If you look at Iran itself, they have put up legislation that regulates their mediation. What we are lacking in this country, and the reason why people are coming up with different legislations to try to regularize or institutionalize mediation, is because we do not have a stand-alone mediation act. If we have this stand-alone mediation act, all these things we are talking about will be regulated. They will realize that mediation is a profession. In fact, for decades, mediation, we have lived under the shadow of arbitration and litigation. Mediation was seen as a small sister to arbitration. It's high time now that mediation needs to have an institutional backbone. It's a profession of its own, and the only way we can put it as a profession of its own is by having a mediation act. And I'm asking mediators all over the world from different institutions with different interests. If we can work together, first of all, to have that act on the table, other things will fall into place. But if we stay in competition, that people are trying to come up with this and this, trying to legitimize themselves in the mediation field, we want to be confused. This problem occurred in Nigeria and other places. We have learned a lot, and we need to have these things put in place.
Yes, I've seen that we also have a big challenge when it comes to public participation and its illegality. So this is another bill that should be... our MPs should really work on it. Now, what is the biggest bottlenecks or challenges in the Kenyan context? Because you've said at least we have also traveled wide and broad. And that is unique to Kenya, that slows down the uptake of mediation, because just like you said, we have a backlog in courts, but unfortunately we don't have a backlog in mediation.
I think one thing is mindset, changing a mindset. People have always thought that when a person suggests mediation is a form of weakness, because we have been set up by our Anglo-Saxon adversarial system to think that we must fight to get everything that we need. That suggesting mediation is a form of weakness. We have to change that mindset in the first place. Number two, the lawyers in this country, I'm one of the lawyers myself, the lawyers in this country need to embrace mediation and advise their clients to at least adopt or try mediation before they go into their system. In fact, in most countries that I've gone to, lawyers have got departments in their law firms, which are departments of mediation. When a client comes, they have to select this, what we call a multi-law system. They have to select whether they need to go to mediation or go to litigation or arbitration, whatever. We need to do that. And then lack of awareness. In fact, you people used to have programs here like Vioja Mahakamani and other things, Vitimbi. It's high time now we work with media stations to be able, media space, to be able to have a program that runs weekly where we can Kenyans can learn that mediation works. Tunaweza kuita ni mchakato wa upatanishi ama uwiano. We have that program running. So we need your people, especially the celebrities we have here in Kenya, to learn. We write for them scripts so that we have a series of programs so that we can create awareness in the public. The other thing is we have an unstructured growth of mediation movement. Everybody is jostling for a position. People want to make it look like a club. They are using what we call the doctrine of exclusion, where they want to exclude others and stand alone as people who manage mediation in this country. Let's work together. We also need to have an umbrella legislation. What I've just told you, what is the Mediation Act. Without that, we are not really going to address the issues that we have right now. So let's put for mediation, and I'm asking the judiciary to help us push this process through. India worked very well because the judiciary and the government supported mediation. So private mediators, we can work together with the judiciary and the government to support mediation. In fact, the judiciary should be in a position to partner with the mediation centers so that the cases can be referred from the judicial mediation centers where there is a panel of mediators who are disciplined, who can work on them. This will help reduce the backlog of cases seriously. So that kind of partnership, like PPPs, working with the public and private sector, will help the judiciary take off in mediation. But using this doctrine of exclusion where a group of people want to isolate themselves and work on their own, this is not going to help us. We have to work together to ensure that this mediation succeeds, the mediation ecosystem succeeds in our country.
But James, where are we in the country? Because you've mentioned that a number of countries are working very closely with the judiciary to actualize mediation processes.
Yes.
And where are we as a country, bearing in mind that we even don't have an act in regards to mediation? And the judiciary, we have the court-annexed mediation, the CM. How far are you working with the judiciary?
By having mediation in our constitution, 2010, that was the starting point. The Civil Procedure Act in Kenya was amended. Section 59 was amended to accommodate mediation, therefore establishing the Mediation Accreditation Committee and coming up with the mediation rules. Right now, we have the new mediation rules. That's legal notes number 145 of 2022. But that's not good enough. There's a lot that we need to do. We need to come up with a system where the judiciary works with experts, works with the private sector to promote mediation. So this is what we need to do. That PPP I've just told you. Establishment of mediation centers at every county, okay? And these mediation centers should have a working relationship with the judiciary in those particular sectors, so that at least when cases come to court, cases are identified. We also need to train our registrars, the mediation registrars, because unless you are a trained mediator, there is no way you are going to identify a case as being suited for mediation. We need to streamline the rules that we have right now, but this can only be done if we have the Mediation Act. That's why I keep on dropping back there. The judiciary has done a lot, I can say that. They started the court-annexed mediation, which has been successful, albeit with a number of bottlenecks. What we need to do is to streamline those bottlenecks and also complement it with private mediation. That way we will succeed in making mediation a success story in this country. So I am only requesting members of the judiciary, if they can involve experts. Because if you don't involve experts like us, we have been in this field for 24 years and we're international mediators, known everywhere. In fact, that's what the Bible says, a prophet is never known at home. People know me. I do cases. I do cases internationally. I do cases for international organizations. I teach internationally. I'm a director in the International Mediation Institute, which is a global body. I'm a governor in the International Academy of Mediators. But when it comes locally, when decisions are made that touch on the way forward for mediation, some of us are excluded. And therefore, all these mistakes that you are doing, we are seeing happening, the slow movement of mediation in this country, is because of that doctrine of exclusion. The moment all stakeholders are placed on the table, we will be able to move this mediation the next step in this country. And you see things like this now, people forming something like a mediation council and excluding everybody because they want to control mediation. That's the beginning of problems that Nigeria and other places had. We need to start on a clean slate so that mediation can be successful in this country. Let's
go to the figures. And I was doing the interview. I was preparing for this interview. I noticed and I read somewhere that the court-annexed mediation, which is a part of mediation, has already released over 11.9 billion shillings back to the Kenyan economy. So from your view, how can the wider adoption of private mediation further contribute to Kenya's economy?
Let me tell you that if we adopt mediation, private mediation in every county, the backlog of cases will be capped. The duration within which a case is being resolved will take less. Let me tell you, statistics show us that by the time a case is settled, it has already eaten in that 1% to the value of the subject matter of the dispute. So if you, for example, you were filing because you were claiming 400,000 Kenyan shillings, by the time you conclude your case, that 1% of 100,000 shillings is gone from your 100,000 shillings. First, in the legal fee that you pay, the court filing fee, you have to close your business and disrupt your systems to be able to attend the court and other related vagaries of the court system. We also have an average period within which a case takes in court to be concluded because of the backlog of cases. So if we adopt private mediation, the courts will have very few cases. It will improve the efficiency of the courts to handle matters in the first place. Number two, justice will be cheaper because Article 48 of our Constitution talks about access, the state ensuring that its citizens have access to justice. Access to justice does not mean access to the courts only. Access to justice means empowering citizens to be able to resolve their disputes peacefully and cheaply, okay? Justice is very expensive and is complex for the common man at home. That's why before you stand before the court, even if you are representing yourself, you may not win your case. You need the service of a lawyer, which is expensive. So if we have private mediation, disputes like family disputes, small trade disputes, even complex disputes, can first of all find their way to the mediation center. They will be resolved quickly, and therefore this will, instead of people engaging in courts, they'll engage in their business, and therefore we shall be improving our economy. So this is for the purpose of portraying what the courts are already doing. The courts have done their part, although not 100%, but they have done their part, and they have released a number of amount of money to the system. If we now portray that with promoting private mediation in the country by bringing up these mediation centers, I'm telling you now, dispute will be easier. Look, go to Rwanda. If you go to places like Rwanda where they have really established the private mediation, you'll be surprised that most people don't even think about the courts. They have that conflict resolution culture where they believe that we can resolve our disputes before moving into a third party to make a decision on our behalf. Right now, what we have done, especially in the country, we have already established Nyamira Mediation Center. We have Kakamega Mediation Center, Bungoma Mediation Center, Eldoret Mediation Center, and the Kisii Mediation Center are being launched in the course of the year. We are moving to other areas within the country to ensure that we have mediation centers. Once these mediation centers are established, and we are starting to train their managers, staff this week. Once we have all these mediation centers established, we shall be seeking a partnership with the judiciary, such that matters can be referred directly to the mediation center instead of being referred to individuals. We can be able, once a matter has been referred to a mediation center, the matter will be managed there. And once agreements have been reached, those agreements then can be forwarded to court, and they can be adopted and converted into judgment. That way, I'm telling you, we shall have achieved the aim or the spirit of Article 48 of our Constitution, ensuring that each citizen has free access to justice. So private mediation is the answer, and I'm asking Kenyans wherever they are, please, can we work together to ensure that we make private mediation a reality? Yeah,
and beyond the figures, beyond commercial disputes, in what other sectors can private mediation really have a lot of immense potential, and especially for even our young Gen Z who are...
Let me tell you, you've just mentioned about Gen Z, and I'll start from there.
Yeah.
We have what we call peer mediation for schools. Peer mediation. This peer mediation program, which we have started rolling, we have already trained peer mediators in the country. We are trying to educate young people in primary and secondary school, even tertiary level, to be able to inculcate the culture of conflict resolution once they are very young. They can be able to resolve their conflict within the school environment. Number two, when they go home, they can carry these skills over to school. Because in school, there are a lot of conflicts that happen in the dormitory, on the playground, on the hallway, in the bus going home. Yeah. If students are trained at that particular level to be able to resolve their disputes, then this culture of conflict resolution will start very early. We are also encouraging universities to have this program put in there, a compulsory subject in all the subjects within the university, the curriculum. At the same time, we have different types of mediation now that you asked. We have family mediation to resolve disputes for divorce and separation. We have marital mediation to put families together. We have workplace mediation. We have community mediation. We have what we call victim offender mediation, which probably I can just explain in 1 second. You know, in our criminal justice system, we always believe that when an offense has been committed, the offense is against the state. And I want to take you the offense you're talking about, rape. If there is an offense of rape and somebody has been raped, the offender is usually brought to court as prosecution witness number 1. They are charged and sent to prison. And then we ignore the victim. So the victim needs to start healing, the healing process. So victim offender mediation, which is restorative justice, has also come in a big way to be able to ensure the plight of the victims. And it's a process that has really worked in other countries where we put it in place. We also have mediation for construction disputes, tenant landlord mediation. Mediation is a forest, and if we adopt in the country through our mediation centers, almost all disputes right now in Western Kenya and other parts, people are mediating some criminal matters. In fact, if you go to Uganda right now, what we call plea bargaining has been converted in a way that these criminal matters are mediated in such a way that instead of doing it the way we do it in our country, in our country, plea bargaining, we usually ask somebody to admit to a lesser offense so that we can reduce the sentence. There it has been done in such a way that it becomes still a form of mediation. And let nobody tell you that criminal matters cannot be mediated. There's a book in our library. By the way, we have the largest library in Africa here in Nairobi. Mediation library. People travel from a long distance to have gotten books, donations from the International Academy of Mediators. There's a gentleman, and may his soul rest in peace, his name is Jeff Crevis, who died and donated their own library to Nairobi. So students from universities and other places are free to come to our library and read and expand their knowledge in mediation. So there is a lot, mediation is a huge area of practice, and we are encouraging people to do so. In the last, whatever I want to say, the way forward, because a few minutes ago I saw people talking about politics, we also have a 10-point way we can be able to promote mediation in our country. Just a second. Yeah. What we need is a pro-amicable dispute resolution culture in this country. We need a strong legal framework. So the Mediation Act is so urgent that I request members to come together so that we can make it a reality. We need an active push from the judiciary. Mediation has to be positioned in this country as a first stop. But the mediation, we need to incorporate the mediation clauses in our contracts. There's no way we want to promote mediation in this country unless we have them in our contracts. Okay. We need to mandate mediation before people even go for arbitration. We need to create an indigenous mediation model, but so long as it conforms the international mediation principles, it works a lot. Also, we have to form professional standard bodies that govern the standards of mediation in this country. We are messing it up in a great deal. And lastly, the existing rules and the court proceedings need to be enhanced to encourage greater use of mediation in the country. So I wish I had the whole day to talk about this mediation.
Your final word in regards to where do you see mediation in the next 5 years? I'm hoping that we'll be having a Mediation Act and a Public Participation Act as well.
Yes, I see this country having a Mediation Act. I see the mediation centers all over, in all 47 counties in the country. And I see all the backlog of cases reduced and our economy improved just because we made good decisions at the beginning. But first and foremost, it's important for us to avoid what we call the doctrine of exclusion. Let's all come together as stakeholders to be able to promote mediation in our country and our continent, because that's the only way we can be respected. Because now, currently, we are respected worldwide. In fact, if you go and ask ourselves, like now the Institute of Chartered Mediators and Conciliators in Kenya is a respected institution as a group of professional mediators who sometimes are consulted by international organizations when they need mediators to resolve disputes for the World Bank, disputes for the Copper Belt in Zambia. They come to the Institute of Chartered Mediators and Conciliators, where we have a group of, we have what we call self-credentializing. We have a group of mediators who are covered by a strong code of conduct and who can give good mediation service to the members of the community. The whole thing is standards. We're also members of the International Mediation Institute. In fact, mediators who qualify, who have experience, can approach Mediation Training Institute, who will assess them and will assist them to be certified as certified mediators of the International Mediation Institute and many other international bodies. Mediation has a good future so long as we do it the right way, because the beginning is the most important thing. If we get it wrong now, we shall go astray as some other countries are still struggling. But Kenyans, we are on the right track. Let's do it the right way.
All right. Well said as well, James Mangerere, who is the president of Mediation Training Institute, that is MTI. We have been looking at mediation and everything that surrounds mediation. Remember, there's a quote annexed to mediation, and he says that not only cheaper and faster, it also brings people together. Well, we're hoping that we'll be having the Mediation Act as well as the Public Participation Bill. That's why we put a cap on KBC Channel 1 News Check. Thank you so much indeed for joining us. It's time for me and my colleague to put a cap on what we have been talking about and giving handing the baton to the Swahili desk with the Kurunzi Mashinani and Tamrini. Kasichana Masha is coming up next.